Welcome everyone to today's webinar on tools to identify and report hiring discrimination. We're going to give everyone about 30 seconds and then we're going to get started. Thank you for joining today's training on tools to identify and report hiring discrimination. This training is presented to you by Switchboard. Switchboard is a one-stop resource hub for refugee service providers in the United States. Here is a quick overview of your settings in Zoom. This is a Zoom webinar, so you're joining on listen-only mode. Due to the large number of learners on today's webinar, we've disabled the chat box. However, you do have the option to send messages to the speakers and co-facilitators via the Q&A. Keep an eye on the chat for messages from Switchboard and links to various resources we'll be mentioning throughout. Today's webinar will run for 90 minutes and it is being recorded. You will receive an email with the recording, slides, and recommended resources within 24 hours. The webinar transcript along with the recording will also be posted on the Switchboard website within the following days. Last, we ask that you kindly complete our webinar satisfaction survey at the conclusion of our session today. This short 3-question survey helps us here at Switchboard continuously improve our training and technical assistance offerings for you all. And with that, I am delighted to introduce our speakers today. Liza Zamd is a senior trial attorney in the Department of Justice's Immigrant and Employee Rights section, IER. Liza investigates and prosecutes employment discrimination based on citizenship and immigration status, national origin, unfair documentary practices, and retaliation. Liza has developed an expertise in investigating complex pattern or practice matters. She also dedicates substantial time to assist refugee service providers and ORR-funded organizations to work through employment issues that arise with clients. I am also delighted to introduce Ramya Sankaran. Ramya is a trial attorney in the Department of Justice's Immigrant and Employee Rights section, IER. Ramya enforces protections against employment discrimination based on citizenship and immigration status and national origin, unfair documentary practices, and retaliation. Ramya also engages in outreach and policy work to assist Afghan and Ukrainian parolees who came to the United States through the Operations Allies Welcome and Uniting for Ukraine programs with employment-related issues. In addition, Ramya serves on the Department of Justice's Civil Rights Division Working Group to address hate incidents against Asian American and Pacific Islander communities. And let's take a look right now at our learning objectives for today. By the end of today's session, you should be able to identify the types of hiring discrimination prohibited under the law, use and interpret Form I-9 and documentation required by the E-Verify system, recognize the rights of newcomers as job applicants and employees, and describe the process of effectively filing a charge with the Immigrant and Employee Rights Section IER, as well as the potential remedies and support available. So let's get started with today's presentation. Awesome. And before we really jump into our content with our speakers, today's speakers have asked us to start off with a Slido to get some background information on your work history as refugee service providers. So please take out your mobile device and scan the QR code on this screen to participate in this poll. You can also join on a web browser by going to slido.com and entering the code on your screen. And again, that question is, how long have you worked in refugee services? like most folks longer than 5 years at present, but 1 to 2 years is also coming in strong, and quite a few people less than 6 months. Awesome. And we actually have one more Slido here. Same thing, please take out your mobile device and use that to scan the QR code on the screen if you would like to participate in this poll, or alternatively, you can join on your web browser. The question here is, have you ever contacted the IER for assistance? And speakers, I'm actually going to turn it over to you in case you want to comment on the results of this poll and get us started.
Great. Well, hopefully by the end of the presentation, if nothing else, you will know what IER is, and that's the office where Ramya and I work. But it's great to see that there's about 10% of you who have contacted us, because it means that for the 90% who haven't, you're now going to know of a phenomenal resource that is available to you and your clients, and that hopefully will be of assistance. So we can go to the next slide. Yeah. So how does IER, the Immigrant and Employee Rights section, protect workers from employment discrimination? There are generally 3 ways in which we do that. The first is through our investigations. Oh, sorry, you go back to the original slide. Yeah, thank you. The first are through our investigations. And this is when we investigate or sue a company because of employment discrimination. The second is through policy work. Both Ramya and I do policy work with other agencies, which means that we try to make sure that IER's equities are being thought about and influenced in the policies that other agencies like USCIS and other parts of the Department of Homeland Security, that they integrate worker rights equities into their policies. And the third is outreach, which is what Ramya and I are doing with you right now. So those are the 3 ways in which we help enforce worker protections against discrimination. Next slide. So there's going to be 4 things that we will generally cover today, 4 different topics, 4 different types of discrimination. The most important part for you might be the part at the end where we talk about hotline, which is another form of outreach. But in terms of the law, the 4 different types of discrimination that IER investigates are citizenship or immigration status discrimination, national origin discrimination, unfair documentary practices, and that's the part that involves the Form I-9 and E-Verify, and it is by far the most common type of discrimination that we see. And the last is retaliation. And so I'll turn it over to Ramya to discuss citizenship status discrimination.
Thanks so much, Liza, and thank you all again for being here today. So like Liza said, one of the types of discrimination that we address is citizenship status discrimination. And the type that we address is citizenship status discrimination that occurs in hiring, firing, or recruitment or referral for a fee based on an individual's citizenship status or their immigration status. So an example of this might be an employer having a US citizen only hiring policy, for example. Under the law that IER enforces, the groups that are protected from this type of discrimination are US citizens, US nationals, refugees, asylees, and recent lawful permanent residents, or also known as green card holders. It's worth mentioning that these special immigrant visa holders are a group who often come to the United States with what's called a machine readable immigrant visa. They are lawful permanent residents, so they are also generally protected from this type of discrimination. Again, this type of discrimination is in hiring, firing, recruitment, or referral for a fee. So discrimination based on the terms and conditions of employment. For example, if an employer is paying a refugee, a lower rate than they are other citizenship status groups, that's not the type of discrimination that would be covered by our office, but there may be other federal agencies that can address these types of issues. Next slide, please. Okay, so is preference based on citizenship status ever permissible in hiring? Yes, there are narrow exceptions to this rule, and they are fairly rare, but it is worth noting that if a law, regulation, executive order, or government contract requires an employer to place a citizenship status restriction on hiring, that is permissible. However, employers are not allowed to impose additional restrictions beyond those that are actually required by said law, regulation, executive order, or government contract. So, for example, a federal contractor can't have a blanket US citizen only hiring policy for every job when there are only certain jobs that are actually covered by the citizenship status restriction under their contract. This is, again, just one narrow exception. The other area that is sort of an exception is individuals who are not protected under the citizenship status discrimination component of the law. So individuals who don't have work authorization, individuals who require sponsorship, they are not protected by that part of the law, but they may be protected by other parts of the law that IER enforces, which we'll talk about in a little bit. Finally, we'll note that, even if there is citizenship status discrimination occurring that isn't covered by the statute that IER enforces, there may be other federal or state laws that provide additional protection. So it's always worth considering that. Next slide,
And Ramya,
please.
what if a refugee service provider wants to get a job for their client, but the employer says, oh, we have a government contract, so we can't hire refugees or asylees. Do they just have to take the employer's word for it?
Great question, Lisa. Thank you. No, they don't have to just take the employer's word for it. If there is an exception that applies, the burden is on the employer to demonstrate that there is this legal requirement or requirement under a government contract stating that the job is only limited to US citizens. So this is definitely the kind of situation where we would strongly encourage service providers or workers to reach out to IER for further assistance. And again, we'll talk about our hotline in a little bit. Okay, I'll turn it over to Liza.
Sure. And it's so important because we have lots of settlements with employers that said initially, oh, we have a government contract, we can only hire US citizens. But then when IER read that contract, it didn't say US citizen only. And so the employer was wrong and they were violating the law that IER enforced. And so Ramya is absolutely right. You don't have to take anybody's word for it. You can contact us. For national origin discrimination, it doesn't matter if your clients fall within one of the groups that Ramya had mentioned, because all work authorized people are protected under the national origin discrimination part of the law that IER enforces. And it is also about hiring, firing, and recruitment or referral for a fee. And we cover employers that have between 4 and 14 employees. For larger employers, which would be the vast number of employers that you're going to be working with, there's another agency, the Equal Employment Opportunity Commission, and they enforce national origin discrimination in a much broader way. So for example, when Ramya was talking about that a refugee, was maybe, let's say, making $5 less per hour than a US citizen, that's a term or condition of employment under citizenship status discrimination that we likely wouldn't be able to investigate. But that could also be a type of national origin discrimination that the Equal Employment Opportunity Commission could investigate. And so there are other laws, I guess is the take-home point for both citizenship status and national origin discrimination. There's other laws that also protect your clients. And so don't forget that, but you can always contact us and we're happy to refer you to those other laws. Next slide. So national origin discrimination can also be very broad. It's not just the country that your clients came from. It can also be the way they dress, their ancestry, whether they can speak English, whether they have an accent. These are all kinds of national origin indicators. And so if an employer says, for example, that somebody needs to speak fluent English in order to work at a job, that could be illegal. And or if a employer says that they don't want somebody to speak with an accent, that could also be illegal. And there are some exceptions, just like we see with everything. So for example, with the accent, if let's say it's an employer that operates a 911 call center, well, then it might make sense because of business requirements that the 911 call center operators speak with unaccented English because they don't want to have to repeat themselves in a life or death situation. But if you're working at a clothing store and somebody's asking you, where the shoe section is, it's not a life or death situation if the person might have to repeat themselves. And so for the vast majority of jobs, somebody's accent is not something that an employer can take into account. And of course, just like with what Ramya was saying with citizenship status discrimination, that you can't have an overbroad restriction. The same holds true for national origin. And so in the case of a restaurant, it might be a requirement for the wait staff to speak some English so that they can speak to the patrons and maybe change their order or explain the menu. But it would probably be illegal if the restaurant said that the kitchen workers also needed to be able to speak English, because they can likely do their job with just knowing a few words of English. And so a restaurant couldn't say that everyone needs to be able to speak English, because they're putting restrictions on some jobs that they're not allowed to have. And so if you have any questions about these things, you should let us know, because we do interventions, which we'll talk about later, meaning an informal process. And so hand it over back to Ramya.
Thanks so much, Liza. Next slide, please. Okay, so before we move on to some additional content, we have a poll question for you all. And as before, feel free to use the QR code on the screen or join at slido.com using the number you see at the bottom. So we're interested in hearing whether you've ever worked with an employer who asked to see a DHS, Department of Homeland Security, or also known as an immigration document for hiring. Okay, so it looks like many have had this experience or have worked with clients who've had this experience. Okay, great. So now I'm going to talk about unfair documentary practices, which, as Liza mentioned before, is by far the most common type of discrimination that we see. And actually, a lot of people don't know that this is actually discrimination. So we're hoping that the information we share today will be helpful in that regard. So what is an unfair documentary practice? An unfair documentary practice is when an employer requests more or different documents than are required, rejects documents that appear genuine, or specifies that a worker has to provide certain documents based on that person's citizenship status or national origin. And this commonly occurs during the Form I-9 and or E-Verify process. Next slide, please. So again, these are the ways in which unfair documentary practices may occur. So when these things occur based on a worker's citizenship status or national origin, this may be a violation of the prohibition on unfair documentary practices. An example of this that is pretty common is an employer who says, oh, you're a permanent resident, well then I need to see your permanent resident card or green card. This may constitute an unfair documentary practice under the statute that IER enforces. Next slide, please. So I'm going to talk a little bit about the Form I-9 because the Form I-9 process is often when unfair documentary practices are occurring. So just some background on the Form I-9. The purpose of the Form I-9 is to establish a worker's identity and their authorization to work in the United States. Importantly, the purpose is not to verify an employee's particular immigration status. So the purpose is not to verify that somebody is a US citizen or they are a lawful permanent resident. It is just to verify that they are authorized to work in the United States as well as their identity. The US Citizenship and Immigration Services, or USCIS, is responsible for the Form I-9, and they have a lot of resources available on how to complete it. So the I-9 Central website, the M274 Handbook for Employers is available through the USCIS website as well. These are all great resources for questions about the I-9. Of course, IER is a resource as well. Although we do not administer the Form I-9, we do investigate allegations of discrimination that occur during the I-9 process, and we're also available to help with questions that come up during that process. Instructions for the Form I-9 are available online. And the Form I-9 also has, as part of the form, what's called the list of acceptable documents, which describes most of the documents that employees can present to establish their identity and their permission to work in the United States. And it is really important for employers to make sure that all workers have access to all pages of the instructions, including the list of acceptable documents. One thing to note is that the Form I-9 very recently changed. So the image that you're seeing on this screen is actually the new Form I-9. The old version of the Form I-9 is still in use, But this is just something to be aware of. If you're seeing the Form I-9, it looks a little different. That's because it is. And on the slides that we're using today, you'll see updated images of the I-9, but both are still in use at this time. Next slide, please. So again, the Form I-9 is intended to verify identity and permission to work in the United States. It is not to verify a particular immigration status. And this is a link here on this slide to I-9 Central, which is the resource I previously mentioned that's very useful for lots of questions and answers regarding the Form I-9 process. Next slide, please. Okay, so this is section 1 of the Form I-9. And section 1 is the portion of the Form I-9 that the worker completes after they've received and accepted an offer for employment. And they typically, they have to complete it by the first day of work, but they can complete it before that as long as they've already accepted an offer of employment. One exception to this timeframe is that staffing companies who are recruiting workers to then refer over to an employer can ask workers to complete the I-9 before they actually assign workers to a particular job. But in general, the worker has to fill out section 1 on or before the first day of work. And this is an image of section 1 of the Form I-9 here. Next slide, please. Okay, so part of section 1 is this attestation box. This box is something that the worker has to check off to indicate what their citizenship or immigration status actually is. And there are 4 different categories here in this attestation box. The first is citizen of the United States. The second is a non-citizen national of the United States. Third is a lawful permanent resident. And fourth is a non-citizen authorized to work other than those covered in these other categories. The non-citizen authorized to work, number 4, previously was known as an alien authorized to work, or AAW. So some of you who have helped your clients with filling out the I-9 might be familiar with the term alien authorized to work. It's not a term that's being used anymore, but non-citizen authorized to work means the same thing. It covers the same groups of individuals. And it's actually a broad category that includes anyone who is not a US citizen, US national, or lawful permanent resident. And some of these non-citizens authorized to work are asylum applicants, for example, who are like temporarily authorized to work. There are other categories who are temporarily authorized to work. Other non-citizens authorized to work are indefinitely authorized to work. These, for example, namely include refugees and asylees. So in this box, the non-citizen authorized to work category includes a field, which you can see the arrow pointing to, for the worker to enter the expiration date if they are temporarily authorized to work. So if a worker is indefinitely authorized to work, like a refugee or asylee, it may be that they don't need to include a date in that portion of the form. Others who do actually have an expiration date on their employment authorization documents do have to include a date there. So just be aware that sometimes the date doesn't need to be filled in, at other times it does. Now, if an individual does have permission to work that ends at a certain point in time, they will have to then later show their employers Form I-9 documents on or before the expiration date. And we'll talk a little bit more about that process, which is called re-verification, a little later on.
And Ramya,
please go ahead, Lisa.
What if the worker is a refugee or asylee and they have an employment authorization document and the document has an expiration date on it? Do they still put NA in that field?
That is a great question. Actually, Lisa, how would you answer that question?
So no, refugees and asylees never put in an expiration date in the alien authorized, or sorry, it's no longer the alien authorized to work, right? It's the non-citizen national authorized to work field, because their permission to work doesn't ever expire. It's sort of like US citizens, we have a passport and our passport has an expiration date, but we're still US citizens and we still have permission to work even when that passport expires. And so the same would be true for the refugees and asylees. So your parolee clients have to have an expiration date on there because they have to keep on asking for permission to work. But refugees and asylees, they should never put an expiration date there because their permission to work has nothing to do with their EAD.
Thanks so much, Liza. Yeah, and that's an incredibly important point, and it's definitely something that comes up, with employers. Sometimes there is confusion about that, and that's again a situation where it's a really great idea to reach out to our hotline for further assistance. And the last thing I'll mention here is that employers are not permitted to require somebody to provide a document that verifies the status that they've selected. So regardless of what somebody's citizenship or immigration status is, they're allowed to choose any acceptable document or documents from the Form I-9 list of acceptable documents to show their identity and permission to work in the United States. So just because you're a US citizen doesn't mean that you have to provide a US passport. There may be other options. Similarly, just because you're a lawful permanent resident, you don't necessarily have to provide your green card. And we'll talk a little bit more about that later on in the presentation. Next slide. Okay, so again, as I just mentioned, when verifying a worker's documentation, a worker is allowed to choose what documents they provide. So the worker can choose from this list of acceptable documents, an image of which is on the screen here. They can either choose to show a document from list A or a combination of one document each from list B and C. The employer does not choose, the worker does. Employers, again, cannot tell workers to present a specific document. They can't ask for more documents than necessary, and they can't reject valid documents. And it's actually not an excuse for an employer to say, I'm just not familiar with this particular document. That's not a reason to reject it if it is a valid document based on Form I-9 rules. So some of the examples of problems that we see with respect to documentation for the I-9 are employers asking non-citizens to show proof of their immigration status. Like I mentioned previously, asking a lawful permanent resident for a permanent resident card. That is not required. Anyone, regardless of citizenship status, can choose to present any documents from these lists. Other issues that we sometimes see are employers not accepting valid documents. So for example, a list B and C document combination might be an ID or driver's license and an unrestricted social security card. Sometimes employers might be hesitant to accept these kinds of documents from a worker who appears to be from another country. That, again, may be a violation of the statute that we enforce. Sometimes we see situations where employers are rejecting documents that they're just not familiar with. So one example that we'll talk about in more detail later is an I-94 with an asylum stamp. That is a valid I-9 document, but employers who maybe haven't seen it before might be a little more suspicious because they know the worker wasn't born in the United States. So we strongly encourage employers and workers to reach out to IER with questions about what types of documents are acceptable. Other resources are the I-9 Central website, the MQ-74 Handbook for Employers, and of course, our hotline.
And Ramya,
yes,
one thing that you noted about the list of acceptable documents is that this is the new version. And if folks look at the bottom, they can see that now it shows acceptable receipts. But there is a big hole in the acceptable receipt notation in that it doesn't state that the parolee I-94s are valid. It just has the refugee I-94 receipt. And this is because when they were creating the new list of acceptable documents, the rule about parolee I-94s hadn't come out yet. So even though it's not on the bottom of this I-9, the rule is still the same as you know it. Parolees can use their I-94 for 90 days. And we're going to talk about that later, but just so that you know, it does say the refugee I-94, but it doesn't receipt, the refugee I-94 receipt, but it doesn't have the parolee.
Thanks so much, Lisa. That's an incredibly important point. And, we've been getting a lot of questions on our hotline about Afghan parolees, Ukrainian parolees who are trying to use their I-94s and sometimes having difficulties. So, please be aware, even though, again, it's not on that list, it may be valid as an I-9 document. And like Lisa said, we'll talk about that more in a little bit.
And
Okay.
Ramya, you had mentioned, the example a couple times of an employer asking a permanent resident for a permanent resident card. And, these folks often have refugees and parolees, as you know, as their clients. And so is it okay for the employer to say, oh, you marked that fourth box, I need to see a work permit or I need to see an employment authorization document?
Great question. No, it is not okay. Regardless of citizenship status, whether you're a refugee, asylee, or some other status, you are still permitted to choose which documents you want to provide. So if a refugee or asylee has an ID or a driver's license and an unrestricted social security card, they can certainly provide those. They can provide any other combination of documents or document from the list of acceptable documents. It's not permissible for an employer to ask somebody for a work permit or EAD, employment authorization document specifically, just because they're a refugee or asylee.
Okay, so we've been getting some good questions that I've been trying to answer as things go on, and so keep them coming. So Ramya had talked about the fact that people need to prove their identity and their permission to work. But then what happens when their permission to work expires? And so not all workers need to be re-verified, and that's what this process is called, re-verification. But some workers do. And so any worker who showed an employment authorization document is going to need to be re-verified. So that's why for your refugee and asylee clients, if they can show other documents, they might prefer that, because then they won't, if they show their ID and their unrestricted social security card, then they won't have to show other documents again. But we're going to talk about re-verification. And just so that you understand, the person doesn't need to prove their identity again. They're still who they said they were. The question is, do they still have permission to work? So next slide. So for section 2, which is initial hire, the worker gets to choose between either showing a list A document or showing a list B with a list C. And that's what Ramya had discussed. But for re-verification, this is when the person is working at the employer's office already. The worker gets to choose either a list A or a list C. And the reason is because the person's identity is totally irrelevant. They've already proved it. They don't need to prove it again. They're still the same person. And so they just need to prove that they have permission to work. And list A documents show permission to work. List C documents show permission to work. And so the worker gets to choose, which means that if your client has an employment authorization document and an unrestricted social security card, those are, let's say, the only 2 documents they have. They don't have a state ID. They could, if they wanted to, show the employment authorization document for section 2 and immediately for the supplement, which used to be called section 3, show their unrestricted social security card, same day, same moment. And so the employer can complete section 2 with the employment authorization document. They can complete the supplement with the unrestricted social security card, and then they don't need to track the worker anymore because the worker has already proven their unending permission to work. But of course, this only applies to your refugee, asylee, and SIV clients, because for parolees, they don't have an unrestricted social security card. They do have to keep on proving that they have permission to work. And so, it's really important when you call IER that you know what status your client has, because the status of your client will determine what document options they have. Next slide. So here are some examples of documents that do not require re-verification. So list B documents, those identity documents, they don't require re-verification. And one question that had been asked that might be helpful for you to know is about the transportation boarding letter. That's the letter from the Department of State that has all the photos of the family, and then often CBP will put a stamp on it. That letter is valid for a year, and that is a list B number 2 document. And we'll talk about that in a moment. And although it expires, just like a driver's license might expire, it should never be re-verified. And then permanent resident cards, those could have a 2-year expiration date, a 10-year expiration date, or no expiration date if they're the old kind. And it doesn't matter, the employer should never re-verify permanent resident cards. And so this just shows that it really depends on the type of document that the person shows. And you don't need to be document experts, because Ramya and I, we are document experts. We work in an office of document experts. And so you can just call us and ask us whatever questions you have. Next slide. Okay, so this next slide is going to cover a lot of the most common questions that we get from refugee service providers. And it's probably not going to answer all of your questions, but it's just going to be enough to whet your appetite so that you know how to call us and what information we might need from you. So EAD extensions, there's a couple of them, but the important thing to know is that some employment authorization document extensions are valid for certain groups of people, while others are not. So parolees generally do not have an employment authorization document extension just because they applied for a new EAD, but your refugee clients would. Or if somebody has applied for permanent residency, then they might also. And so it just really depends on the status of the person. But the extensions can occur in many formats. And now with re-parole, there's going to also be a different type of extension. So you don't need to know all the rules. You can just call us and we're happy to explain them to you. But the take-home point is some people get an extension, some people do not, but the letter looks the same regardless. And so you won't be able to tell from that language at the bottom whether your client gets the extension or not, because they put the same language with all the letters that they send. For permanent resident card extensions, that's typically also a letter, and it can extend the validity of a permanent resident card. Now it's for 48 months, and it is the rules are different for permanent resident card extensions depending on whether it's a 2-year card, if it already expired, or if it hadn't expired. So you could call us if you have questions for your SIV clients about that. Now for List B number 2 and List C number 7 documents, let's see if we can go back to the slide. One more. Okay, so when you're looking at the list of acceptable documents, List B number 2 is any document issued by the federal, state, or local government agency that has a photo or a description of the person. And so that's why the transportation boarding letter, even though it's an 8.5 by 11 piece of paper, that's why it's considered an identity document, because it fits all the characteristics of that List B number 2. It has a photo and it's issued by the Department of State. That's a federal agency. So there you go, it's an ID. Now List C number 7, that's a little bit different. It's also a very broad type of document. It's also a very broad type of category. It's not one document, it's many. And it can include things like your asylee I-94, not the refugee I-94, not the permanent resident I-94, but the asylee I-94. It could be a U visa I-94. It could be a naturalization certificate. It could be a letter from immigration. It can really depend. It could be a refugee travel document, not the transportation boarding letter. That's a different document, but the document that refugees in the US and asylees get when they want to travel abroad, that refugee travel document can be a List C number 7 document. And so the important thing to remember that for List B number 2 and List C number 7, it's many, many, many different kinds of documents. And so sometimes when your clients are having a hard time getting a state ID, you might want to call us and see if we can try to strategize with you where your client could get a List B number 2 document, because some public library cards fulfill the requirements for List B number 2. Or, the Henderson, Nevada food handler's license can fulfill the requirements for List B number 2 documents. So we can also try to strategize and help you figure out if there are other documents that your client might be able to get. I mean, maybe not, but there's no harm in calling. Okay, back to the prior slides. So 2 slides forward. Receipts for lost, damaged, or stolen documents. This is a rule that applies to everyone, and essentially they're valid for up to 90 days. And so if your client lost their driver's license and they give a receipt for their driver's license, well, some receipts actually is probably a bad example, because some driver's license receipts are actually valid List B number 2 documents that aren't limited by 90 days. But let's say your client's social security card is lost and they show a receipt for the social security card, then that would be valid for up to 90 days. And then for machine readable immigrant visas, as Ramya had explained, there's some confusion about the expiration dates, but essentially it's the date of the stamp. It's not the date that's printed on the visa itself. That's just by when the worker has to enter the US. Next slide. So when we're talking about these EADs, one thing to note is that for some of the employment authorization document extensions, for people who have temporary protective status, they do not need to show any other documents. And I don't think that most of you deal with people who have TPS. Although actually some of your Ukrainian or Afghan clients might apply for TPS. So, maybe that's wrong of me to think. But when there's an automatic extension, it is truly automatic. They don't need to show anything else. And so they might also be eligible for the extension that comes with the letter. So they show the EAD and the letter together, which means that they might have two extensions that are happening at the same time. And that's okay. You can call us if you have any questions. Next slide. So for the SIVs, as I had explained, they might have that machine readable immigrant visa, and it's the stamp. That's the date that you care about because it's usually valid for 1 year from the date of the stamp. But your SIV clients can get unrestricted social security cards. And so if they have an ID and they have that unrestricted social security card, they don't need to show their machine readable immigrant visa. They don't need to show an immigration document. That's sort of like the take home point for all of this. There is no job in this country where for I-9, people need to prove their citizenship or immigration status. And so just keep that in mind as you're thinking about what options your clients might have. Next slide. All right, so for parolees, it's a little bit confusing because of the receipt rule. But some parolees do not need to wait until they get an employment authorization document in order to start working. And so they could, for most Ukraine and Afghan parolees, they can use their I-94 and they can use it for up to 90 days. If the I-94 expires, at day 50, then they can't use it for 90 days. They can only use it, for the 50 days. But if it, if it's valid for at least 90 days, then they can use it for 90 days. And the rule is at the end of the 90 days, the worker can show either an employment authorization document or an ID and an unrestricted social security card. But your parolee clients do not get unrestricted social security cards. They're not eligible for them because they are not permanently work authorized. And so the ID with the social security card option is not a real option for them. It's like someone telling me, hey, Liza, if you do 50 push-ups, then, you can get $1 million. It's like, well, great. I'm definitely going to miss out on that $1 million because there's no way that I can do 50 push-ups. It's sort of the same thing for your parolee clients. But for your refugee clients, they would be able to have that option for the unrestricted social security card. And yeah, go ahead.
Sorry to interrupt you, Lisa. We got a great question in the chat that I think is pertinent to the slide, if I can jump in with that.
Sure.
Okay, so what should happen when the I-94 that a parolee has been using for the first 90 days is no longer valid, but their EAD has still not arrived?
Yeah, it's really tough, but the answer is they can use that I-94 to get another job for 90 days, but the employer has the right and is actually required under the law to fire them or at least to take them off payroll if they can't show a document that proves their permission to work. And so they can use the I-94 for an unlimited amount of employers for 90 days each time. And I know that that's not great because it's really hard to find a job. And then to keep on having to find a job every 3 months is not awesome. But they actually have that benefit that a lot of parolees do not. Like your Cuban and Haitian parolees, they can't use their I-94 at all, as we'll talk about in another slide. And so at least your Afghan and Ukraine parolees are able to. Go ahead. Oh, sorry, I didn't know if there was another question. Okay, so next slide. So this is just an example of the many different kinds of I-94s, because there's the I-94s that are 8.5, 11 pieces of paper that you can print from CBP. There's I-94s that come at the very bottom of an 8.5 by 11 piece of paper, and it's just that strip at the bottom. There's your asylee I-94s that are like an index card. There's many different kinds. And so employers are often confused, but we are happy to clarify any confusion that they might have. And so they or you could always call IER if they have questions. And one thing to just note in case we don't have much time at the end, when Ramya and I say call IER, you're not waiting on the phone for half an hour. It's just a couple of minutes before you speak to me or Ramya or any of our coworkers, because the calls don't go to a call center, they come to us. And so we are the ones who are giving you information. So you're talking to an attorney or an investigator, and so you know that the information is high quality. Next slide. Okay, so this slide is one of my favorite slides in the deck because it just shows how complex it can be for one type of document. So we're using the I-94 as an example. And if you see across the top row, it's the different statuses. So there's the refugee I-94, the asylee I-94, the permanent resident I-94, the Afghan and Ukrainian I-94, and then we use as an example the Cuban, Haitian, Nicaraguan, Venezuelan I-94. So you see that for some people, like for permanent residents and for refugees and for some parolees, it's a List A document. For other people, like asylees, it's a List C document. And then for other people, like with the Cuban, Haitian, Venezuelan parolees, it's not an I-9 document at all. They can't use it. And then it's also valid for different amounts of time. It can be valid for forever, like with an asylee I-94, or it could be valid for 90 days, like with a refugee I-94. And we know refugee I-94s don't expire. Like we understand that. It's just that the I-9 says that refugees can only use it for 90 days. And so this is why it could be really complicated for employers, because depending on the status and depending on, depending on the status, the validity of the document changes or doesn't exist at all. And so for these reasons, you can always have the employer contact us. They can contact us anonymously. You can contact us anonymously, but we're happy to explain these things. Next slide. Okay, so now that we've spoken a little bit about the I-94, how comfortable do you feel after having seen this chart? And do you have any lingering questions?
Lisa, we have a few questions that folks have dropped in the chat that I'll direct to you about I-94s. So somebody asks, is there any plan to extend the 90-day allowance for using I-94s in light of the extreme delays with worker permits? They have numerous clients who've been in the United States and are still waiting for their worker permit.
There is not, that I know of, any plan to extend the validity of the I-94 for the parolees. Of course, for other workers, the I-94 is valid for more than 90 days, right? So for your asylum clients, they're valid for forever. But this is essentially the rule that has been created. And, we work closely with USCIS, but we have not heard, any, public discussion of the extension of I-94s.
Yeah, and I'll just add, regarding Afghan parolees and Ukrainian parolees are groups that have sort of their own set of rules and documents that they're able to use. And IER is always able to assist with questions that come up for Afghan parolees who have come through the Operations Allies Welcome Program, as well as Ukrainians who've come to the United States through Uniting for Ukraine. And Afghan parolees in particular, who have been using their I-94 for employment authorization, they have the opportunity to apply for an extension or for reparole. And right now I'm dropping a link to that information in the chat for everybody to see.
Oh yeah, thank you so much, Ramya. That is something that I definitely should have mentioned. And so depending on whether they've already applied for asylum status or permanent resident status, they might not need to apply for reparole, or they might need to apply for reparole. So we can send you all of that information from USCIS. We don't make the rules, but we're happy to send them to you. So it seems like there are people who agree this is complicated, but hopefully you feel a little bit more comfortable, at least being able to spot. Now Ramya will talk to you about Social Security number issues.
Thanks so much, Liza. So switching gears just a little bit, and we've actually gotten a couple of questions about this in the Q&A already, so hopefully this content will be helpful. So with respect to Social Security numbers and whether you actually need a Social Security number to start working. So the answer is for the Form I-9, as long as a worker has sufficient documentation to complete Section 2 of the I-9, a document from List A or documents from B and C or an acceptable receipt, the employer can hire the worker and the worker can start work even if they have not yet received their Social Security number. One situation in which this is a little different is if an employer uses E-Verify, which is a government program that we're going to talk about in just a little bit, that's part of the verification process. E-Verify does require a Social Security number, but the worker can still start work. And there is a way for the employer to fill out E-Verify for that worker, indicating that they're waiting for the Social Security number. So for the Form I-9 and E-Verify, you do not have to have your Social Security number in order to start working. Sometimes questions come up about whether for tax purposes, for example, you need to have your Social Security number. That's a question that is best directed to the IRS. And other agencies, the Social Security Administration, the Department of Homeland Security, the EEOC, they all have guidance about questions that come up related to working while waiting for a Social Security number. And links to all of that guidance is on this slide. So I would strongly encourage you to consult that information. And please also call IER if this issue comes up. We are more than happy to help and point employers to the relevant guidance when this comes up. Somebody had asked whether about background checks and whether you need a Social Security number to complete the background check. That is, a separate issue. If there is some other reason the employer is requiring a Social Security number unrelated to the I-9 and E-Verify, that may be permissible, and that might be something that just falls outside of purview of what our office does. But when in doubt, call our office and we're happy to assist you, and we can give you a sense of whether what's taking place is something that might be permissible or not.
Yeah, and
Next
Ramya,
slide.
your audio was breaking up a little bit, but just to clarify for folks, that we can still do these interventions. So even if it's a background check issue and the employer says, oh, I need a Social Security number for a background check, we can still call the employer and explain that actually, the Equal Employment Opportunity Commission, they said that it could be a type of national origin discrimination for an employer to require a Social Security number for any reason. Doesn't matter what the reason is. And so by sending them the information from the IRS and SSA and the EEOC and DHS, all of that information explains you don't need a Social Security number to get paid, to get hired, to start working, to conduct a background check. You don't need that number. And so we're happy to explain this in a nice way to employers, and so that they can be educated, because often they don't know. Sometimes they think that you need a Social Security number for a background check, but that is false. You actually do not need a Social Security number for a background check.
Thanks so much, Liza. Yes, it's a very important point. And again, just to reiterate, when in doubt, reach out to our office and we'll be happy to help you when these situations come up. Okay, so now I'm going to talk just a little bit about E-Verify. So what is E-Verify? E-Verify compares the Form I-9 data with government records. IER does not administer E-Verify, but like we do with respect to the I-9, we investigate discriminatory use of the program. If an employer uses E-Verify, the proper order is for the worker to be hired, the I-9 to be completed, and then the final step is for the employer to run the worker's information through the E-Verify program. Very importantly, employers may not ask workers for specific documents for either the Form I-9 or for E-Verify. And we do see this come up where employers think sometimes that they need a specific document for E-Verify, and that is not the case. Another thing that is important to be aware of is that E-Verify users, E-Verify employers have to use E-Verify for all of their new hires. They cannot be selective about which workers they run through E-Verify. For example, they can't just run all the non-US citizens through E-Verify. That's not permissible. There are a couple of things to note about how E-Verify actually changes the I-9 process. While an employer cannot require a specific document for E-Verify, if a worker has chosen to present a List B document for the I-9, if the employer is an E-Verify user, that List B document has to have a photograph. If they're not an E-Verify user, it doesn't necessarily have to have a photograph. But if they are and the worker chooses to provide a List B document, it has to have a photograph. And this information is available on USCIS's website that describes the E-Verify process. As we mentioned earlier, Social Security numbers are not required to start working, but eventually the employer does have to include the individual's Social Security number if they are an E-Verify employer, but the worker can still start work while they're waiting. So basically what the employer should do is delay running E-Verify for a worker who's waiting for their Social Security number, allow the worker to start and to continue working while they're waiting for their Social Security number. And then when the employee actually gets their Social Security number, the employer can indicate in E-Verify that the reason that they waited more than 3 days is because the worker was waiting for a Social Security number. And there's actually in a drop-down menu in E-Verify, there's an option called awaiting Social Security number that the employer can select. One other thing to be aware about with respect to the E-Verify process is that there are some documents that E-Verify employers must make a photocopy of. Those are US passports, green cards, and employment authorization documents, or EADs, also known as a work permit. Employers can make copies of other documents if they want during the I-9 process, but they should do it consistently. It's not a best practice for them to only copy certain workers' documents or certain types of documents.
So Ramya, Ramya, on that point, one of the participants asked, are there laws that govern what types of documents people can show, or is the employer allowed to decide for themselves and they can just create whatever policies they want for the I-9 or for E-Verify?
Yes, so there are rules with respect to filling out the I-9 and completing E-Verify. An employer cannot, under the law that IER enforces, request specific documents for either the Form I-9 or for E-Verify. So an employer can't, really make their own rules and say, well, these workers have to present this type of document. That kind of thing is not permissible, and it could very well violate the statute that IER enforces if employers are making rules based on citizenship status or immigration status. Would you add anything to that, Liza?
Yeah, and even if something is non-discriminatory, like let's say an employer says, nah, I just don't want to accept state IDs, and I'm not going to accept state IDs from anyone, regardless of whether they're US citizens or not US citizens. They're not allowed to do that because there's laws and regulations that say that the state ID is a valid document. So even if it's not discrimination, they're still not allowed to do it. So for the I-9 and E-Verify process, there's like really, really strict rules that are like very detailed. And so it's not like a vacation policy where employers can often just decide what they want for people's vacation policies. For the I-9 process, there's very explicit rules as to what documents are valid, what documents are not, and employers cannot make that decision.
Yeah, that's a great point. Thanks so much, Liza. Okay, next slide, please. Okay, so we're going to talk just a little bit about something called a tentative non-confirmation or a mismatch, which is a result that can come up in E-Verify. So usually what will happen is an employer will put a worker's information into E-Verify, and the result that comes back is work authorized. Sometimes what comes back is what's called a tentative non-confirmation, or a TNC for short. And that is a result that requires both the employer and the worker to take certain steps to address it. Very importantly, a tentative non-confirmation is not proof that the employee does not have permission to work in the United States or that they are undocumented. It is just a mismatch between what's the documents that the worker provided and what's in the government system, and the mismatch needs to be addressed. And the steps for the worker and the employer to address are on this slide. And when an E-Verify tentative non-confirmation or mismatch results, there is also the ability for the employer to print from E-Verify instructions for both the employer and the worker to follow the instructions that you see on this slide. So basically, the worker has 8 government working days to contact either the Department of Homeland Security or the Social Security Administration if the worker wishes to address the tentative non-confirmation. So the worker gets to decide, do they want to actually contest this tentative non-confirmation, or do they just want to leave it? Now, if a worker doesn't select to address the tentative non-confirmation, the tentative non-confirmation can become what is known as a final non-confirmation. And if a worker has a final non-confirmation, the employer can choose to terminate the worker. So it's very important for workers to indicate that they wish to address the tentative non-confirmation and to start to take steps to do so within 8 government working days of receiving the tentative non-confirmation. So as soon as a worker decides that they want to take action, as long as they do so within those 8 government working days, the employer cannot use the tentative non-confirmation as a reason to fire or suspend the worker. Workers must be allowed to continue working while they have a tentative non-confirmation, even if the process takes some time. As long as they indicated that they want to take steps to address it, and they've started to address it, they've reached out to either the Department of Homeland Security or Social Security Administration, that is sufficient. And so I'll stop there and see, are there any questions about this tentative non-confirmation thus far? And then we'll talk a little bit more about final non-confirmations.
No, I'm looking here. So how would a refugee service provider know if an employer is being selective about E-Verify?
That's a really good question. I think that if a refugee service provider happens to have clients, who, well, yeah, that's a good question, because if they're running all their, refugees through, but not U.S. citizens, the service provider may not know. I think it can be hard to, to be able to determine that. You would have to know, whether other workers are going through this process or not. I don't know, Lisa, how would you answer this particular question?
Yeah, I think you're right. I think it's hard to tell because if you don't have context for other people, and also even if you have friends who are US citizens who work at that same employer, most of the time people don't know if they're being run through E-Verify or not because it's something that the employer does separately. And so you might not know that would be something that maybe is invisible to any individual worker, and that IER would only be able to tell if we're investigating the company and then we see who was run through E-Verify and who was not. But I think you're right, Ramya. I don't know that we would be able to tell.
Yeah, it's definitely a challenging situation, but I think if you have any inkling as a service provider or any feedback from your clients suggesting that maybe the E-Verify program is being used in a way that seems unfair, that isn't online with this process that we've outlined here. For example, refugees are getting tentative non-confirmations and being fired right away, or told, well, this means you're not authorized to work, so we can't, keep you on. Those are the kinds of situations where you should definitely reach out to IER for further assistance. Okay, next slide, please. Okay, so as I mentioned before, if a tentative non-confirmation is not addressed by the employee, or if it's been some time and or the process has been followed to address the tentative non-confirmation and it regardless becomes a final non-confirmation, that is a situation in which the employer is then permitted to terminate the worker. But sometimes a final non-confirmation can be issued in error to a worker who is employment authorized. So if you have a client and you know that they're authorized to work and they've taken the appropriate steps to try to address a tentative non-confirmation, but it has regardless become a final non-confirmation, and you believe it's an error, you can contact E-Verify about this. And the phone number for E-Verify is on this slide. So just be aware that that is also a possibility and a step that you can take on behalf of your clients. Next slide. Okay, so now I'm going to talk about the final type of discrimination that IER addresses. So in addition to citizenship status discrimination, unfair documentary practices, discrimination based on national origin, we also address retaliation. So individuals are protected from retaliation or intimidation, threats, or coercion for trying to assert rights that are protected under the statute IER enforces. So what does that actually mean? So if a worker has filed a charge with IER, has cooperated with an IER investigation as a witness, for example, has spoken up in the workplace about an action that they think is actually illegal under the law IER enforces, for example, firing based on citizenship status or unfair documentary practices. If a worker has called IER's hotline, any action that a worker takes to assert their rights under the law that IER enforces, if they then face retaliation from the employer on that basis, that is something that is prohibited under the statute that IER enforces. And this protection applies to any employer with more than 3 workers. So, please be aware of this protection against retaliation. And it's not just retaliation if a worker is being coerced or threatened in some way, intimidated because they're trying to assert their rights under the law IER enforces. Please reach out to us because that itself could be a separate violation of the statute. Are there any questions about retaliation?
There was one before. What if somebody contacts IER's hotline and we do an intervention, and then the employer takes a negative action against a worker due to the intervention? What would happen then?
Yes, so we would very much encourage you to call IER again or to consider filing a charge, because this could very well be retaliation for asserting a right under the statute that IER enforces. So this could be prohibited retaliation under our statute.
Yeah, and I would just say that we also try really hard when we do our informal interventions to be friendly. And a lot of times employers are actually really grateful that we called because they wanted to hire the person and they thought that they couldn't. And then they have our hotline number in the future so that they don't have to pay money to ask a lawyer questions about I-9 or E-Verify or hiring. They can just call us and we will send them all of the information for free. And so, we try really hard to avoid the employer feeling defensive. And so we have a very friendly way of doing our interventions.
Yes, absolutely. We totally understand that, it can be worrisome to reach out to our hotline, but we definitely try to do our best to, keep things very friendly and somewhat informal when we do this outreach. So now I'm going to talk about IER's investigative process. So in addition to the outreach we do, like today's webinar, in addition to our hotline that we've been encouraging you to call, which we'll talk more about in a moment, we bring enforcement actions. So we investigate allegations of unlawful discrimination. And next slide, please. So workers or their representatives, like a service provider, can file a charge of discrimination with IER, which we would then investigate. And as you see on this flow chart, we also have the authority to open an independent investigation if we have a reasonable belief that an employer has committed a violation. So if we hear about something, maybe on hotline or by some other means, we can open an independent investigation as well. Once we open an investigation, whether based on a charge or independently, we conduct our investigation. We will, go through a process, and it can take a, varying amount of time, anywhere from like 6 to 9 months to longer, depending on the scope of the investigation. And then once we reach a determination, we'll determine what steps to take next. And the possibilities are either we find that we do not have reasonable cause to believe that discrimination occurred, so we will dismiss the charge. And if we are dismissing a charge, we will notify both parties that this is the case. If we do believe that a violation has occurred, we typically try to resolve the matter through a settlement process before filing a complaint with an administrative court. So we will try to work with the employer to obtain appropriate remedies. And we'll talk about what those remedies might be a little later on. If we're not able to reach a settlement, we can file a complaint before an administrative law judge and actually go through the process of litigating a lawsuit to obtain appropriate remedies. One thing that's important to know is that when individuals file a charge with IER, they also have the right to file their own complaint with the administrative law judge, regardless of what happens with IER's investigation. They have to wait a certain amount of time after filing the charge with IER, but IER will let the individual know, now is the time when you're permitted to file your own complaint with the administrative law judge, regardless of what happens with IER's investigation. So please just be aware of that right that workers have. Next slide, please. So what are some of the outcomes that result from IER investigating and finding that discrimination has occurred? So IER may be able to help a worker get hired or rehired. A worker might be able to get back pay for wages that they unlawfully lost because of discrimination. The government can ask the employer to avoid future violations of the law. We can monitor the employer to help them avoid future violations of the law. The employer may be asked to make policy changes so other workers don't face the same type of discrimination in the future. And employers may be asked to pay civil penalties, to pay a fine, essentially, to the government for the discrimination that has occurred. And the amount of that fine can vary, quite significantly. So these are some of the remedies that can come out of settlement and potentially out of a lawsuit as well, if that's the process that we end up following. Okay, next slide, please. I'll turn it back to Liza.
Yeah, so you have a situation that maybe you don't want IER to do an informal intervention. You don't want us to call the employer. You want us to investigate the employer, or your client wants us to investigate the employer. Or maybe you tried an intervention and it didn't work and you're like, all right, we tried it the nice way, but now we want an investigation. That's fine. All charges must be filed within 180 days. And so even if your client was unsure, or you had lost our phone number, or whatever the excuse is, like really, they must be filed within 180 days. It's a very, very strict deadline. The charge forms are available in over a dozen languages. And even if there's a client of yours that doesn't speak any of the languages that have the charge form translations, like let's say you have a client that speaks Quechua, they can write it in Quechua and we will get it translated. And one of the participants had asked whether we have language services available, and we do. And so we can have we can call our language line and then ask for an interpreter. And if it's a very, very, very rare language, like for example, for Quechua, there's not that many Quechua speakers in the US, we might have to schedule a time in order to get that interpreter available. So schedule a time with your client and with the interpreter. But yes, language is not a barrier when speaking to IER. You or your clients can file online, email, fax, mail, but online or email is the easiest option for IER to process. And so, you know, that know that to process a charge, the online option is often the best one. Next slide. So people have been asking about the hotline number, and there it is. I wrote it in response to one of the questions, but it's 800-255-7688. We're open Monday through Friday, 9 a.m. to 5 p.m. Eastern time. And so at 5:01 p.m. Eastern time, the hotline will have been closed. So you'll have to either leave a message or you can wait the next day. But if you have any person's direct contact information, we normally don't stop working at 5 p.m. And so you can always contact us directly if the hotline is closed. Next slide. So what are reasons why you might want to call us? Well, we've already spoken about Form I-9, right? There's a million Form I-9 questions that people have, and we are very happy to answer them. And Ramya also talked about E-Verify and social security number requirements, you know, US citizenship requirements that we talked about in the very beginning, or, you know, being asked to speak a particular language or to have English fluency. These are all things that we've spoken about today. But there's some other things that we can help with too. So for example, if your clients have the correct documents under state law in order to get an ID, a state ID, but the DMV is not recognizing the validity of the documents, you can call us and we can try to help. If your client is trying to get a social security number and the Social Security Administration is not letting them, even though they are allowed to get one, you can call us, we can help. I actually just helped with this exact situation today. There was a office, a Social Security Administration office, that was requiring that people wait 14 days in order to apply for a social security number. But that's not a rule. There's nothing saying that people can't land in the US and go directly from the airport, you know, to the Social Security Administration if they have the documentation that they need to prove their status. And in this situation, it was for refugees. So they had their I-94, they had their transportation boarding letter. So they had all the documents they needed. And so SSA called that local SSA office and explained that there was no, you know, 14-day requirement. And so IER is able to informally help in these ways when it comes to other federal agencies. Now, if your clients are waiting for a long time on their employment authorization document, we can't do anything about that. So we can't help any specific person. But if it's a global issue, like in the example of the Social Security Administration saying no one can get their, you know, social security number, you know, unless they wait 2 weeks, then we might be able to help. And you can err on the side of contacting us. So even if it just happened with one client, but you suspect it might be a bigger issue, you can still err on the side of asking us, and we can let you know if it's something that we can help with or not. The same holds true for airport badging issues. We are able to contact airports and explain what the different validity of different documents are. And we have a lot of knowledge about the TSA security threat assessment process. But this even also extends to things like bank accounts. And so sometimes your clients might be wanting to get a bank account and the bank is like, what's this I-94? I don't understand it. I can't use this document. We can call the bank and explain what the I-94 is and send them links to all the different resources from the Department of Homeland Security. And so we have helped people get bank accounts, get mortgages, you know, get IDs, get airport badges. We do this informally. But we're happy to help however we can if it has something to do with the person's documents, because this is an area of expertise that we have. So these are just some examples of when you can contact IER, but you should always feel free to do it because the calls are free. You don't even have to identify who you are. You certainly don't have to identify who your client is if you just want to ask some questions, and we're happy to talk to you and give you information. So the hotline there, you will see that there's an email address on our website, but we get 30 days to respond to an email. And so if you want immediate assistance, the hotline is the best way to go. And like I said, it's 2 to 3 minutes usually waiting. That's it. When we get slammed with calls because, like for example, earlier this year, in April, when the Afghan I-94s, I'm sorry, the Ukraine I-94s were expiring, and people were losing their jobs, we got a ton of calls, and we also then worked with USCIS for them to get information up on their website. And so maybe in those situations, you might have to wait 5 minutes or 8 minutes, but it's really quite fast. Next slide. Okay, so you have already been asking some great questions, and maybe now is the time for me and Ramya to go through and answer some of them. So I have one right now about, what's the best way to report an employer if the employer is not paying the worker for the hours that they've worked. So that is a Department of Labor issue. There are state departments of labor, there's the federal Department of Labor, but you're right that is a Department of Labor issue. People are also allowed to sue if they want, they can get an attorney and they can sue. But if it's not discrimination, meaning that if the employer is not taking into account the person's race or religion or national origin, things like that, they're just not paying some of their workers, then unfortunately the Department of Labor is generally the only resource from the government that would investigate these types of issues. And so, Ramya, so we have a question here. What's the timeline that an employer needs to wait before they say to the worker, okay, worker, I need your social security number. Like, I can't wait a single day more. Like, I need your social security number.
Yeah, so there isn't really a specific timeline. However long it takes is however long it takes. And whenever the individual gets their social security number, depending on what, the process is at the Social Security Administration, that's when the employer can fill that out and e-verify.
Yeah, exactly.
It's a good question.
Okay, so this is actually something about the new policy, Ramya. So when a parolee's parole ends and they have a pending asylum application, and we're going to assume here that they're talking about Afghan parolees because it really does depend what your status is and what country you're from. And it didn't say so in the question, but let's assume we're talking about Afghan parolees. So they have a pending asylum application. What can they do? What options do they have? Because of course their social security cards are restricted, so they can't show their restricted social security card. Their EADs are going to expire. And what can they do?
Great. So it's a very good question. Like Lisa said, it really does depend on, what type of parolee. As we talked about before, different parolees may or may not even be able to use, their I-94 for work authorization verification purposes. But for Afghan parolees who came in through the Operations Allies Welcome Program, that's typically Afghans who were paroled into the United States with the class of admission OAR or PAR. On their I-94. And there is a little bit of nuance to that. So I'm going to drop the link in there again to the information about this. But for these Afghan parolees who came in with these classes of admission, OAR, PAR, who have then applied for asylum or adjustment of status to become a lawful permanent resident, do not need to apply for reparole when their initial period of parole expires. Instead, DHS is considering on a case-by-case basis extending the original parole period. So individuals who've had their initial parole period extended will be issued a form I-797C from USCIS, which will be sent to the address that the person has on record with USCIS. And that form I-797C notice will serve as proof of their extended employment authorization. They don't need to obtain an EAD. That I-797C is sufficient. This can be, this is a new policy that has come out, a new rule that has been made clear by USCIS. These Afghan parolees are authorized to work incident to their status, but employers may be unfamiliar with this, so please do reach out to us for questions. Please consult USCIS's resource about this. And yeah, please contact us because we're very, very happy to help. And I'm dropping the link in the chat again.
So Ramya, there's a question here that a refugee lost their job because their EAD expired. And so what options does the refugee or does the service provider have?
Sure. So, what's important to remember is that, so if somebody has been, improperly fired because of their citizenship status, or, because of an unfair documentary practice, which, may be what is occurring in this situation. If somebody had presented at the time of initially completing the Form I-9 valid documents, and then they are improperly re-verified, and the employer says, now we can't keep you because you haven't been able to show any new documents. That could be an unfair documentary practice. It's these kinds of situations are very fact specific, but this is definitely a situation in which you should call IER to talk through the situation and get some further assistance.
Yeah, exactly. Because we can do the intervention if the client just wants to get their job back immediately, and we can even ask for back pay. But if the client wants an investigation, then yeah, they can file a charge. And so, you and your client always have the option of, you can try the hotline. If the hotline doesn't work, we can file the charge and do the investigation, or you can just file the charge and do the investigation. We have a lot of settlements with refugee and asylee workers. And so this is not something that is new to us. And we have a lot of experience investigating these types of allegations. And so there's a lot of other questions. Okay. So one job
Ramya, I just
seeker.
wanted to let you all know, just 10 minutes left total, and we have about 5 more minutes for questions. So
Okay.
anybody want to get in a last minute question or two, just wanted to let you know the time. Awesome.
Okay, great. So Ramya, a job seeker was told that because he has an employment authorization document through Ukraine parole, the employer would never hire him for a position where he has access to financial information, just entry-level positions. Is this a problem?
It could be a problem, and that I would strongly encourage, this service provider to call IER's hotline to talk through the specifics here. Employers are not permitted to, make hiring decisions based on citizenship status. There are some situations in which an employer may need to obtain permission from another federal agency, such as the State Department, to be able to give workers from certain countries access to information. But sort of a blanket policy of saying, all individuals from this country cannot have these types of jobs, could be problematic. So it does sort of depend on the specific facts, but this is the situation you should contact IER about on our hotline.
And here we have another issue where there's an employer who had sponsored folks under United for Ukraine. And actually, this is a question that had arisen that I typed the answer. But when we said that people who require sponsorship are, an employer doesn't have to hire them, we were talking about employment visas. It is also true that people who have parolee status are not protected from citizenship status discrimination that Ramya had spoken about. So if an employer says, I don't want to hire any parolees, that could be illegal under other laws, but not under the law that I hear. But in this situation, that there was an employer that sponsored the United for Ukraine parolees and is now deducting from their paycheck their sponsoring fees, housing, the flights, things like that. And so, in that situation, it really depends on the state law. Certainly, people are not allowed to make less than minimum wage. They always must be making minimum wage. But it might be, depending on what the employer had signed when they sponsored the person, there potentially could be a violation of the agreement with USCIS. And so you can definitely contact us, and this would be something that IER wouldn't be answering, just immediately on the phone. This is something that we would likely need to get more information about to see whether the agreement between the employer and USCIS allows for such things. And then if it does, then we would direct you to the state law regarding unpaid wages or the deductions of wages, because it just depends on state law. And so, let's see. We have one more question here. We already answered that one. Yeah, so we know that there's a lot of social security number requirements for job applications, but again, you can contact us and we can try contacting the company, and we have a lot of success. It's informal. We don't investigate these types of issues, but we do have a lot of success convincing employers that they should, best practice is to have a workaround so that people can apply for jobs and they can definitely get paid. I promise you, they can definitely get paid. That's what the IRS guidance and that's what the Social Security Administration guidance is about. They can get paid even if they lack a Social Security number. Okay, so we only have a couple seconds left, so maybe Lauren, if you want to start your wrap up.
Awesome. Thank you so much, Lisa and Ramya. Yeah, let's review our learning objectives one more time as we close. So today in our webinar, you should now be able to identify the types of hiring discrimination prohibited under the law, use and interpret Form I-9 and documentation required by the E-Verify system, recognize the rights of newcomers as job applicants and employees, and then finally describe the process of effectively filing a charge with the IER, as well as the potential remedies and support available. And before we share our recommended resources, we'd also like to ask you to help us help you. This survey is extremely important to help improve our future trainings. The survey is 3 questions long. It only takes about 30 seconds to complete. So we want to ask you now to please take 30 seconds and complete this survey, either by scanning the QR code on your screen or by clicking the link in the chat. Awesome. Our speakers have put together a list of recommended resources for you all to supplement today's content. You can see them listed on the screen here, and you will receive all of these resources in an email in the next 24 hours. For more training and technical assistance, we ask that you stay connected with Switchboard. You can email us at switchboard@rescue.org, or you can visit us at www.switchboardta.org and follow us on social media at SwitchboardTA. On behalf of all of us at Switchboard, thank you for learning with us. Thank you to our speakers today, and we hope to see you again soon. Thanks, everyone.